I'm named as the personal representative in the will. Can I begin to act? Hi, I'm Darren Findling of the Probate Pro, and the answer is no. You can begin the probate process, but you have no legal authority to act on behalf of the deceased person's estate. The legal authority comes from the probate court. Having a will does not avoid probate. Having a will is the beginning process to probate the will and to go through the legal process of probate to appoint a personal representative, to admit the will, and then to allow for the probate administration to occur, and then for the distribution of the assets through the probate court's authority. The legal authority is done through a court process that includes the appointment of a personal representative as set forth in a letter of authority. This letter of authority gives the personal representative the authority to act. Just because you're nominated in the will does not necessarily mean you're going to get appointed by the court. So first, the will has to be admitted to probate. And then secondly, the court has to find that the person nominated in the will is suitable to serve. If the will is admitted to probate, the person nominated in the will has the highest order of authority for purposes of selection by the court to be appointed personal representative. Now, if you have a will and you're in possession of it, you have a duty pursuant to statute to, with reasonable promptness, get that will filed with the probate court following the death of the individual. You don't have the authority to just stick it in your safe and hold on to it. You have a duty, a legal obligation to file that will with the probate court in reasonable prompt time. So this probate process is a requirement after somebody has died to get the assets from that person to the people identified within the will, and the personal representative performs that role. But until such time as probate is commenced and the letters of authority are issued, nobody has the legal authority to act. So it's important that after the individual has passed away, you work with a skilled, competent probate practitioner to begin the probate process, because beginning it allows you to get those letters of authority to allow for things to take place. Why is this so important to begin timely or quickly? Well, all of the financial affairs of the individual who has died, they don't just stop, meaning the debts that they may have, the credit card bills, the mortgage obligation, the property tax obligation, they don't get paused because of the death of the individual. They continue. So it's important to timely get that estate open and get those letters of authority issued to give somebody the legal authority to address and administer the probate estate. And probate is a complicated, not necessarily an intuitive process. If you've got questions about probate, about the responsibilities, duties, and obligations of a personal representative, or any probate question at all, reach us at 1-833-PROBATE or visit our website at theprobatepro.com.